Good evening, Craig. Can you hear us?
Let me turn it up a little bit, Lewis. Now I can.
Okay, very good. Thank you. This meeting of the special meeting of the Corporation Board is called in accordance with our dates and agreements, subject to our violation and fining rules. As a bit of background for everyone's benefit, on July 27th, it was brought to our attention that 1753 Banbury was displaying a large sign or banner on the exterior of the home. On July 28th, a letter was sent to Craig Lucy, the owner of this home, that under our deeds and agreements that he had 10 days to remedy, take the sign down. And this display constituted, in the letter it stated that the display constitutes a direct violation of Article 8, Section 3 of the Deeds and Agreements governing Gibson Island properties. Specifically, Section 3 says permitted signage, except to the extent specifically allowed by law, any temporary signs or any signs of any kind, none shall be erected or displayed to the public view on a lot without the prior written consent of the board. The only signs that are allowed by either an owner or a resident is a sign that is not to exceed 12 inches in height or 24 inches in width, provided that the location, color, and design of all signs should be kept in character with the should be in keeping with the character of the property. And really, the only permitted signs are those indicating the street number and or family name of an owner for a lot. There was no response to our letter that was sent on July 28th. So on August 7th, a letter was sent indicating Mr. Lucy's failure to remedy the violation and setting this meeting and the required 15 days notice thereof. The letter also spelled out that under our deeds and agreement, continuing violations can be fines for up to $250 a day, plus us recovering our attorney's fees. That's why, which brings us to here, which was 15 days notice. When we hold a hearing like this, both sides are allowed to have counsel present. And Mr. Lucy has asked for time to state his case, and he has been granted 15 minutes to do so. And so without ado, I will turn it over to you, Mr. Lucy.
Mr. Sarkis, Gibson Island HOA board members, and specifically the 5 HOA board members who are crossover Gibson Island Club board members and represent a quorum on both boards, including Mr. Rick Edmonds. The fair housing flag flying in the same exact location on the 1753 Banbury home as the American flag was flying for 30 days with no complaints by the GIC and with written accolades to Lucy by at least 2 members of the GIC community, including Manus Cooney, flying side by side thereafter, is honoring the Fair Housing Act in the gated Gibson Island Corporation's 99% white neighborhood, which still has no ADA compliant parking, restrooms, and ramps throughout the GIC's $50 million of improvements opened to the daily public customers of the Boatworks, St. Christopher's by the Sea Church, open to all, the daily public operations of the United States Post Office, the daily public operations of the Anne Arundel County Water Department facilities, for-profit weddings, corporate meetings, and corporate outings hosted on GIC-owned improvements and attended by mostly public persons and vendors, and hundreds of daily public contractors and maintenance vendors who comprise the plus 325,000 trips by vehicles through the Gibson Island Gate and into our neighborhood each year, is not a banner nor a sign as previously defined and approved by the GIC, nor a billboard. This fair housing flag, I've got my 15 minutes, Lewis, thank you. This fair housing flag is flying.
I just wanted to say that we're not recording this, and we object to any recording of on either video or voice recording.
Lewis, you are recording this because that's what Zoom does, otherwise I can't see you and you can't see me. So it is being recorded, you are recording it. This fair housing flag is flying the first paragraph of the unanimously agreed to opinion of 3 Federal Circuit Court judges, Judge Niemeyer, Judge Harris, and Judge Brunner. This flag is flying the published Fair Housing Court opinion, the federal court opinion, the GIC HOA has been seeking since the GIC decided to sue the Lucys in March 2020 to prevent the disabled and those associated with the disabled from living in and enjoying the Gibson Island neighborhood. And the GIC board has continued to choose to spend many undisclosed millions of dollars of GIC stockholder money fighting against the Fair Housing Act over the past 9 years since August of 2016. Each GIC stockholder has been forced by the GIC boards to pay tens of thousands of dollars for these words. For years, the Gibson Island Corporation has opposed the efforts of Craig Lucey to build an assisted living facility on the Gibson Island, a waterfront community in Maryland. Litigation ensued, and discovery produced an extensive record dating back years, with the parties hotly disputing material facts and the inferences to be drawn from them. We conclude that a reasonable jury could find that the corporation violated the Federal Fair Housing Act and the Maryland state law by refusing to make a reasonable accommodation to its land use restrictions for the Lucys' proposed facilities, by retaliating against Lucey for protected activity, and by discriminating on the basis of disability. We therefore vacate the district court's grant of summary judgment to the corporation. The GIC's letters dated July 28th, July 31st, and August 8th are inaccurate, invalid, discriminatory against the disabled and those associated with the disabled, continue the more than 9 years of retaliation and false light by the GIC HOA and the club against the 5 Lucey stockholders, and over the past 5.5 years also against the group home on Gibson Island, and club's joint website, and the Gibson Island GIC and the club's frequently broadcast emails to the GIC stockholders and club members. We demand this discrimination, false light, inaccuracies, and retaliation against the disabled and Lucys, and immediately. There is no provision governing banners in the fraudulently induced deeds nor in the Internal County Code. Further, we have no idea why the GIC would be referencing a banner when what is flying at 1753 Banbury are 2 flags, a fair housing flag and an American flag. The references in the GIC made to Article 8, Section 3 of the fraudulent deed states, except to the extent specifically allowed or required by law, no sign or billboard of any kind or character, including temporary signs, shall be erected or displayed to the public view on a lot without the prior written consent of the board, provided that location, color, nature, design, supporting structure, I repeat, supporting structure, lighting, and construction, I repeat, construction, of all permitted signs shall be in keeping with the character of the property and in accordance with the corporation documents, which define signs as needed to be constructed and supported. On March 13th, 2021 and March 29th, 2021, the GIC HOA defined and approved a sign for the Banbury House to be made of wood hung from a signpost in a location not attached to the home, not flags flying from the 3rd floor and 2nd floor of the home. The definition of a billboard of every kind is an outdoor advertising structure that displays commercial messages for products, services, or events not directly related to the property where the sign is located. It's typically a permanent structure and is used for advertising that is rented or leased. The GIC has twice falsely discriminated, claiming on the 28th and August 8th in writing that a banner has been affixed to the exterior of the property located at 753 Banbury. And if true, banners are somehow now wooden signs. The GIC has already specifically defined and approved on March 13th, 2021, March 29th, 2021, what the GIC considers to be a sign, which is wooden, or billboards. Banners are not billboards or signs. The fraudulent deeds nor the Internal County Code have prohibitions against banners and do not have any prohibition against flags. For the record, from a longtime flag retailer and a separate longtime flag manufacturer, banners are held in place with sleeves while flags are flown using heading material and brass grommets. Neither the fraudulent deeds nor the 1925 deed and agreements amended on January 27, 2015, which are the valid deeds, prohibit the flying of flags from a stockholder's home or boat. Having a hearing and threatening unreasonable fines or any fines of any kind against a group home for the disabled for flying a fair housing flag next to the American flag is discriminatory and retaliatory. To be clear, there are no banners displayed on the 1753 Banbury home. The 1925 deeds and agreements last amended on January 27, 2015, and reconfirmed each time each of us pays our portion of the long-term HOA debt each month, confirm the valid deeds. There are no restrictions in the valid deeds for banners or flags. Please immediately stop holding the 5 Lucy stockholders and the group home on Gibson Island in false light. Federal law, specifically the Fair Housing Act, prohibits discrimination based on race, color, religion, sex, familial status, national origin, and disability in housing-related activities. This includes the display of flags that support these protected classes. An HOA cannot prohibit the display of a fair housing flag simply because it is a political or social statement, nor can they ban flags based on race, religion, or other protected characteristics. By fabricating GIC HOA rules that do not exist against displaying a banner that does not exist, and which banner is not defined in those GIC HOA rules, HOAC rules themselves are fraudulently induced, and discriminating against an 85-year-old United States Marine helicopter pilot, Captain Andrew Parker, and those associated with Captain Parker, who is a disabled Vietnam War veteran, for owning a home in the Gibson Island neighborhood exactly how Judge Richard Bennett described in his June 5th, 2020 federal court ruling that 48 out of 200 homes in the Gibson Island are owned by LLCs and trusts, and Captain Parker is allowed to hire medical services per Judge Bennett and have food catered and have guests, and which ownership structure was disclosed and confirmed by me during the 3.5-hour recorded and transcribed Zoom call interrogation of the Lucys by the GIC with no objection on August 21st, 2020, and no objection during the 60 months since then, while specifically the GIC HOA counted the LLC and trust votes before and after Judge Bennett's June 5th, 2020 ruling, and counted those LLC votes for the fraudulent deeds on June 23rd, 2021, and since then, and threatening fines for the display of fair housing flag displaying only the unanimously agreed to opinion of 3 federal circuit court judges from a lawsuit caused by the GOC HOA, flying side by side with the American flag is beyond discriminatory and retaliatory, and further demonstrates the GIC's flagrant and reckless disregard for the Fair Housing Act and the rights of the disabled and those associated with the disabled to live and enjoy any neighborhood in America of their choice. The deeds and agreements recorded on July 15, 2020 were not agreed to by 100% of the GIC stockholders, property owners, and under Maryland law, community associations cannot unilaterally take away property rights from homeowners without their consent. Please see Ridgely Condominium Association case and also the Oakhampton Association case. Additionally, the Maryland Homeowners Association Act does not permit the amendment of governing documents if the HOA has long-term debt secured in part or whole by annual charges assessed in accordance with a declaration, which the GIC does. Further, the deeds and agreements recorded on July 15, 2021 were fraudulently induced and are invalid and of no consequence. To be clear, the GIC HOA board, aided by attorneys Matthew Kimball and Sarah Arthur, used clever wording to hide the GIC's 2021 attempt to steal the 100-year-old property rights from all GIC stockholders. Prior to each of the 2021 town hall meetings and in all written HOA updates and in the formal GIC written and distributed voting information, each ballot packet contained the same dramatically misleading wording. As previously reported, our goals in updating our deeds and agreements include preserving all the existing property owner and shareholder rights. Mr. Kimball testified under oath that maybe he and Ms. Arthur and the GIC HOA board members did not do so well trying to achieve their written goal to preserve all the existing property owner shareholder rights currently found in the deeds and agreement. The problem is the colon, the end of the goal sentence. As previously reported, our goals in updating the deeds and agreements only refers to the first sentence of each bullet point, not the second and third sentence. This means that the written statement, while our new draft documents consolidates and modernize our existing deeds and agreement, it keeps the basic rights and privileges that shareholders and property owners have enjoyed for years. This was not a goal, but a written commitment by the GIC and HOA to induce shareholders to vote for the fraudulent deeds, which was a deliberate attempt to steal all the GIC HOA style property rights. One of the property rights attempted to be stolen by the fraudulent deeds was a property right granted on January 27, 2015, which each shareholder pays their share of long-term debt each month for all the GIC improvements in exchange for the property right to use all the GIC improvements leased to and operated by the club at no charge other than HOA fees and SCBA taxes, regardless of the stockholder is a member of the club or pays club initiation or pays club dues. To be guilty of fraudulent inducement, something or some things of value must be intended to be taken. Imagine how many millions of dollars less your home would be worth if owning your home and paying the monthly debt on all the GIC improvements did not give you access and use for all the GIC improvements leased to and operated by the club. The valid deeds were last amended by 100% of the GIC stockholders on January 27, 2015 to build an $18.8 million clubhouse, $3.2 million hotel rooms, two-story office building, renovate, install the septic system, renovate the yacht squadron, and health club. This is a 100% GIC stockholder agreement confirmed every month with a payment each of us of long-term debt and guarantees that each GIC stockholders access and use of all the improvements leased and operated by the club. The fraudulent deeds were intended to take away and hold over each stockholder's heads access and use of all the GIC improvements leased and operated by the club. If you do not subscribe to the GIC boards and club boards' 99% white neighborhood vision, void of disabled residents and those associated with them, and void of GIC HOA improvements compliant with the Americans with Disabilities Act. One set of documents emailed to each HH stockholder on June 16, 2021 to induce each stockholder to vote for the fraudulent deeds and following were made commitments, not goals, direct, straightforward commitments in written answers by the GIC to frequently asked GIC stockholder questions. Each of these is clear, written answers by Mr. Kimball, Ms. Arthur, and the GIC board were lies and intended to fraudulently induce the GIC stockholders. And they did exactly that. You guys have them still up. We'll read just one of them. How does the amended deeds and declaration impact my property rights? There's no qualification here. They don't. No lot owner's rights are being taken away. That's a lie and it's a fraud. The deeds are fraudulently induced. They're not valid. I think that's my 15 minutes.
Questions? Ask for questions.
Yeah. Does anybody have any questions for Mr. Lucy? Thank you, Craig. Thank you. We will deliberate and be in touch with you. Do you have any final? Okay. Thank you.